I thought the only thing before us was waiver of sentencing errors.
Correct.
Not anything else.
Correct, because you have a million cases saying defendants can't get out of plea agreements.
Yeah. And on Justice Alito's point about whether these are ordinary contracts or not, if they're not, we might think about unconstitutional conditions doctrine in this area too. And I was a little surprised we didn't have more of that in the briefing before us, and I'm kind of curious why. I mean, as I understand it, the defendant here pleaded guilty to one count of fraud for $32,000. That was the only amount charged in the indictment. And then he wound up being sentenced for something like $500,000 worth of fraud and a whole bunch of other unindicted incidents. And it's not clear to me what benefit he got from his plea waiver, appeal waiver, I should say, that would be proportionate and have a nexus to that additional right foregone.
So let me just, and I think this captures Justice Alito, a lot of defendants are unhappy with their sentences, but when they're mostly guidelines, but when they're within the statutory maximum, courts have universally said, tough luck. That part of the appeal waiver is the assumption that the court will make ordinary errors in sentencing guidelines as long as you're sentenced within the statutory maximum. The government's view is you can sentence someone for 30 years for a misdemeanor, and there's no right to defense. Now, they want to try to rely on maybe something in the contract, but that contract provision doesn't say what the government says. So, or nor the Fifth Circuit. The Fifth Circuit,
with respect, Ms. Blatt, do I get an answer to my question about why we don't have an unconstitutional condition?
The sentence seemed, 51 months and all the fine. I don't think because we're just, yeah, the defendant's not happy with the sentence. Most defendants aren't, but they're within the statutory maximum. So I think that's the answer. The condition of probation, the condition of supervised release is the preposterous one that says you have to follow the recommendations.
Right. One might argue, though, that that's an unconstitutional condition to be required to give up a right of bodily integrity without a compelling showing by the government.
Or any showing.
Any showing.
It's just totally bizarre. The government doesn't defend it. I'm going to get this example out. If there was a law that was passed that said all judges must take antidepressants recommended by their physician, I think you would find it stupidly unconstitutional and offensive.
Well, I think we already have.
And it might be medically appropriate to take antidepressants. It doesn't matter.
Is the problem that you couldn't really